Uh, what this association is the International Association of Young Lawyers. We are currently the only global association of lawyers aged under 45 years old. We have around 4,000 members based in 90 plus jurisdictions. And even if these are young lawyers, 65% of our members are in positions of leadership with their firms. We have been organizing a few events with the American Bar Association Labor and Employment Law section over the past month, especially last year. You may remember that we already organized a webinar last year with a panel discussion on post-COVID related issues at the workplace and a networking session. We've been discussing several times since then, and we really wanted to have this kind of new session today. So I'm really happy that we managed to have excellent speakers from various locations in the world today to discuss the latest trends in international labor and employment law. This panel discussion will be moderated by Michael Filoromo and will be followed by a network session in breakout rooms. So Mike, thank you very much for the hard work you put into this, and I leave to the floor to get it a bit more into details.
All right, thank you, Caroline. I'm Mike Filoromo, and plaintiff side labor and employment attorney in Philadelphia. I'm also the co-chair of, this is a very long title, the Outreach to New and Young Lawyers Committee of the ABA's Labor and Employment Law section. As Caroline said, we and AIJA have been partnering over the past, I think going on a year and a half at this point, on events that are of interest to all of our members. Our committee within the ABA Labor and Employment Law section specifically seeks to involve newer and younger lawyers in the section, and particularly this partnership has been an effort to provide global perspectives on employment law, networking opportunities that we think are really important, and really expanding, I think, the reach and partnership of the two groups. So there's, and I'll plug this at the end as well, but I think for both groups, and we'll talk some about events that we have that take place all around the world. As Caroline mentioned, the ABA and AIJA were, I think, just last month at an event for our international committee in Berlin. And we hope to continue to have those kinds of in-person events as we're able, and in the meantime, or in addition to that, to have these types of events. And one of the ways that our committee within the ABA, one of the things we do in addition to these types of events is we provide speaking, networking, writing opportunities for people becoming more interested in becoming more involved in the ABA, who are interested in labor and employment law. So at some point in the chat here, I'll drop in a way to register if you're interested. I'll put my email address as well if you're interested in speaking and writing opportunities. We have a national big conference for our section every November, and then throughout, starting around February, continuing through May, we have groups within the labor and employment law section have midwinter meetings. So it's more narrower focuses within the general umbrella of labor and employment law. So with that brief plug, we'll move into the program. So the way, as Caroline said, what we're going to do today is we're going to have a panel discussion that'll go for about 40 minutes or so. I'll moderate and I'll introduce our speakers. Well, they'll introduce themselves in a moment. You can put any questions you have for the speakers in the chat, and I will keep track of those. And depending on the nature of the question, I'll either direct it to the panelists as we go, or we've set aside a little bit of time at the end of this section of the program for Q&A. We'll have about 20 minutes or so of breakout rooms. That'll be smaller groups of maybe 4 to 5 of the attendees, a mix of people from all over the country, all over the world. And then we'll come back at the end for a few minutes for some final words and some information about upcoming events for the two groups. So I'm very excited to welcome our panelists. We have Hana Khatib, who is from the UAE. We have Moira Campbell, live from the UK. AIJA Dotson, who is in Seattle, is that right? All right, Seattle, I got it right. And Kate Swearingen, and you are in?
I'm in New York.
I almost said Chicago because half of the ABA is in Chicago. New York, that was going to be my second guess. So I'll allow each of you to take a couple minutes to introduce yourselves, and then we'll jump right into the substantive program. So Hana, would you like to go first?
Yes, sure. Thank you, Michael. Thank you, Caroline, and everyone who's attending, and Michael for arranging this, and AIJA and ABA for this very well organized event. So my name is Hana Khatib. I'm a senior associate at a firm, full service firm called Global Advocacy and Legal Counsel in the United Arab Emirates. I am personally based in Abu Dhabi office, but we have offices in Dubai, Amman, Jordan, and in Oman, Muscat. I work mainly on employment laws and corporate commercial matters. I would say I'm 90% a litigation lawyer and 10% in corporate commercial. And I'm happy to be here today to just give you some brief about the labor laws in the UAE. Thank you.
All right, thank you. And Moira.
Hello, everyone. My name is Moira Campbell. I'm a senior associate employment lawyer at Kingsley Napley LLP. We're a full service law firm based in London in the UK. And I represent and advise employers and senior executives, including partners, directors, and senior employees in all areas of employment law. And particular interests of mine include discrimination and whistleblowing matters and employment litigation.
All right, thanks, Moira. AIJA.
Hello, folks. Thanks for having me. My name is AIJA Dotson. As Michael mentioned, I'm joining you from Seattle, Washington. I am a shareholder with Littler Mendelsohn. It's the world's largest labor and employment firm. I'm also the co-chair of Littler's EEO and diversity practice group. So that means that I spend about 70% of my life doing advice and counsel in the DE&I space, and the other 30% I very consciously continue to litigate. Have done so for the last 15 years, and I do that particularly because when I give DEI advice and counsel, I absolutely want folks to know I'm out there in the field, and you don't get ivory tower advice and counsel from me. So that's me in a nutshell. Thanks again for having me. Look forward to this panel.
All right, thank you. And last but not least, Kate.
Hi, I'm Kate Swearingen. I'm a partner at Cohen Weiss and Simon LLP, which is a union side law firm in New York City. We have about 30 lawyers, and I represent labor unions in various industries, including maritime, laundry and food service, security, healthcare, and postal. Thanks for having me.
All right, thank you. So we have roughly 4 topics that we're going to cover with each of our 4 panelists taking the lead on them. And then I'll ask the others to jump in with their thoughts on it. We're going to keep it conversational, keep it moving. And again, if you have questions as we go, please go ahead and put them in the chat. So starting with Hana, one of the interesting things we learned in the process of putting this together, I knew very little about UAE labor law, and it sounds like it has significantly changed recently. So Hana, why don't you tell us a little bit about some of the significant changes in UAE labor law recent past?
Yes, Michael. So it was this year was the 50th anniversary of the United Arab Emirates for their union. And actually 40 laws were reformed or enacted, and UAE was, represented by the president, had this vision that they wanted to become more in line with the international standards and policies, especially when having, a city like Dubai with big investments and having people working there as experts from almost 190 nationalities. And one of them was the UAE labor law. The old one was enacted in 1980. So we're talking about 40 years of a law that was not changed. There was some very small amendments But now the old law has been abolished and repealed, and we have the new law, which came with many new articles related to anti-discrimination, anti-harassment, and working arrangements, new working arrangements, especially after COVID. And all this was not known in the previous law. And I'm going to speak later, about all those new reforms in the labor law.
Okay. Actually, Hana, just a quick follow-up. I think it might be interesting, and we're going to talk with some of the other panelists. But what are some of the highlights of the new law, and some of the things that's changed?
Yes, so now we have an express and clear article, for example, on protection against discrimination in the workplace. This wasn't the case before. If anyone was, subject to discrimination, they had no other way except for going to the police through the penal code. There was nothing in the labor laws on this, but now the new article sets a rule that discrimination is prohibited if it's on the grounds of race, religion, disability, sex, color, and so on. So this is one of the biggest reforms, I would say, in my opinion. And for the maternity leave, it was increased from 45 days to 60 days. And I know maybe 60 days sound not, like in Europe where you have 6 months or 1 year, but this is something at least very good for, mothers. And then a new introduction is the paternity leave. So now fathers have 5 days of paternity leave that they can take when they have a child. The other thing is that they added adoption to the maternity leave. So even now, if someone adopts a child, they can have a maternity, or let's call it an adoption leave, for 30 days. And this was not at all in the old law. And then the other thing we have is the termination is not allowed for a pregnant woman. And again, this wasn't in the previous law. And this could be translated into discrimination against women in the workplace, and it could lead to fines against the company. And lastly, one of the most important things that is enacted now is termination of contracts in the event of insolvency or bankruptcy of a certain entity in the private sector. And this wasn't the case as well. There was nothing mentioned related to the bankrupt companies, and we had mass terminations because of companies going insolvent or bankrupt, and there was nothing in the law to deal with such mass terminations and hundreds and thousands of cases in the courts. So I would say those are the main highlights, which I find very important.
All right, thanks, Hana. And Moira, obviously, maybe not as dramatic a shift, but what are some of the updates and new developments in the UK on discrimination law?
So there are currently many hot topics in discrimination law in the UK, and I'll take you through 4 of them. So firstly, there's been an increased number of employment tribunal claims referencing the menopause in recent years. And there's currently no explicit reference to the menopause in legislation. So individuals going through the menopause are not automatically protected. However, depending on their symptoms and their circumstances, they can potentially seek protection from discrimination on the grounds of sex or age and or disability and or health and safety legislation. But none of this protection was drafted with the menopause in mind. So there are quite a few hurdles for individuals seeking protection in this area. And the lack of specific protection, together with media coverage, which has been raising public awareness in the UK of the impact of the menopause has led to an inquiry by the House of Commons Women and Equalities Committee, and that's questioning whether existing discrimination legislation and workplace practices should be changed to better protect those experiencing the menopause at work. And the outcome of this inquiry is expected imminently, and it remains to be seen whether any new protection or guidance will be introduced. Secondly, there's been an increased focus on ensuring that employers approach gender identity issues sensitively. For example, there's been guidance published for employers by the Government Equalities Office. There's been an interesting employment tribunal decision clarifying that gender reassignment, which does currently have protection under the Equality Act 2010, but there's been clarification that the definition refers to a spectrum moving away from birth sex, and it also includes individuals who are gender fluid or non-binary. But in contrast to that, we've had a recent employment appeal tribunal decision which determined that gender critical beliefs are philosophical beliefs and they qualify for protection under the Equality Act as well. So there's been quite a lot of debate and consideration of matters relating to transgender rights, and it's quite likely that this is going to continue to be a developing area. Thirdly, there's been increased awareness of the importance of mental health following the pandemic. Many employers have launched initiatives or strengthened their existing provisions relating to mental health and well-being. And also in the disability space, there's been an increased awareness of neurodiversity, and employers are considering how neurodivergent individuals can be supported in the workplace. Finally, recent employment tribunal decisions have indicated that age discrimination is increasingly an issue in the UK workplace, both for older and for younger workers. And some commentators note there's likely to be quite a lot of generational clashes as new generations of workers enter the workforce and older generations retire much later, if at all.
All right, thanks, Moira. And Elisha, same question for the US, significant developments in discrimination law.
Absolutely. There has been such a sea change in the way in which we work, not just in the US, but globally in the wake of 2020, of course, two events that cannot be ignored, obviously, as much as we might try to ignore the pandemic. Certainly the pandemic and in the US in particular, the repercussions of the killing of George Floyd, in the wake of which we saw a massive uptick in social justice awareness in the US and US corporations, which is then had repercussions out into the corporate world globally. But in the wake of that, we see a greater interest in diversity, equity, and inclusion programming, my particular area of interest, and almost a huge pendulum swing towards companies wanting to engage in these practices that can move the needle forward. Of course, US law is written uniquely from the laws of, say, the UK, Canada, South Asia, etc. And therefore, traditional laws such as Title VII, et cetera, perhaps getting in the way of having the most direct path between points A and B in the diversity, equity, and inclusion space. And so what we are seeing more recently is a bit of a correction of that pendulum swing by way of various legislations. Those of you who have heard of it and those who haven't, I can tell you about, for example, the law that was signed by the governor of Florida, which would prohibit unconscious bias training in Florida in particular. It goes into effect on July 1st, so coming up shortly. Hanging in the wings with copycat legislation, we think Texas, Virginia, Tennessee certainly are going to have similar legislation that prohibits unconscious bias training. So a correction of that pendulum swing. That, I think, is, a direction of the wind vis-a-vis not just how legislatures are seeing diversity, equity, and inclusion programming in the U.S., but how juries and judges and courts might see it. So along that line of correction of that swing, we're seeing perhaps an uptick and claims of reverse discrimination. Now, that's a term of art I don't particularly like, the term reverse discrimination. Discrimination is discrimination under US law, where, for example, the entire buckets of communities are protected, right? So all genders are protected, all races are protected. And so individuals in the majority bringing claims of discrimination and harassment, retaliation, etc., those are considered reverse discrimination claims, and more of an appetite for them. For example, a particular case in North Carolina, right around Halloween last year, where there were minimal nominal economic damages, but $10 million found by a jury in a single plaintiff case for punitive damages. Again, direction of the wind with regards to the correction of that pendulum. Also seeing a really big interest amongst employers to better understand themselves in the DE&I space and even beyond. And that means data analytics is a huge hot topic out there. But data analytics, of course, as we know, is not something you can just press a button on. It involves thought and infrastructure, and so really high interest and in space both for care and, if done incorrectly, litigation in the US and beyond. Another thing I'll point out, again, along the theme of this pendulum shift, the state of California and various other states in the U.S. the state of California had actually done it. Other states were considering it, and it was a concept of diversity in boards of directors amongst companies that were headquartered in California. Initially, the legislation required diversity by way of more women in boards. It was adjusted about a year later to add to that definition of diversity individuals from historically underrepresented communities, including LGBTQIA individuals. Two courts in quick succession struck down the law as not conforming to the Constitution. And therefore, we will likely see a chilling effect on similar laws in the US. I predict, looking at my crystal ball, reading my tea leaves, that there will be a greater interest in best practices, regulations for voluntary reporting. We'll likely be moving away from mandatory reporting of diversity statistics. All right, folks, that's it from me. Back to you, Michael.
Okay, so we're going to switch that takes us into the next topic in terms of talking about reporting requirements. Moira, I know one thing we talked about preparing for this is that one approach to promoting pay equity, for example, is to require employers to report the relative compensation of different genders, ethnicities, and different positions. So what can you tell us about pay reporting requirements that exist in the UK now, and any that are perhaps in the pipeline?
Okay, so currently pay reporting requirements in the UK are limited to gender pay gap reporting, and legislation was introduced in 2017, which requires private companies and voluntary organisations with 250 or more employees to publish an annual report containing data on its gender pay gap. And this was with a view to increasing transparency and with the aim of gradually closing the gender pay gap. In that report, certain information is required, such as the mean and median pay gap between the hourly rates of male and female employees, and this is irrespective of their role, so it's quite different to unequal pay. Employers also need to publish the mean and median bonus pay gap, and both of these are calculated with reference to specified pay periods. And the figures must be posted in April of each year on a central government website, as well as on the employer's own website, and must be kept there for 3 years. And for example, the latest pay gap report regarding the period up until the 5th of April 2021 found that overall in the UK, 87.7% of employers have a positive means pay gap in favour of men. And that in terms of non-compliance, there are not many sanctions, but so far they've been limited to the sending of letters and some naming and shaming by the Equality and Human Rights Commission. So the main incentive for compliance is the protection of an employer's reputation. And there's no current requirement for employers to provide any narrative explaining any pay gaps, but the government is currently reviewing the gender pay gap reporting regime, and one proposal for change is to introduce an obligation for employers to produce a narrative as well as an action plan and targets for closing the gap. In terms of developments for potential new pay gap reporting, there's been much debate over introducing mandatory ethnicity pay gap reporting in the UK, and a consultation took place into this in 2018. And whilst awaiting the outcome for that consultation, some large employers began reporting their ethnicity pay gap voluntarily, and much support was expressed for the introduction of mandatory ethnicity pay gap reporting. However, the government responded to the consultation in March 2022 and confirmed that it will not be legislating for mandatory ethnicity pay gap reporting at this stage. But it says it supports those who wish to do so voluntarily, and new guidance for voluntary ethnicity pay gap reporting is expected to be published this summer. And so it's likely that this area is going to continue to develop, and that there will be continued calls for implementation of mandatory ethnicity pay gap reporting. So watch this space. And in terms of disability pay gap reporting, in May 2021, the government rejected calls to introduce mandatory disability pay gap reporting, and instead it relies on an existing voluntary framework. And the framework is in place for employers to report on disability, mental health and well-being in the workplace. Again, it's aimed at larger employers, and it's suggested that employers provide a narrative to explain activities in relation to the recruitment and the retention of disabled people, and to report on the percentage of individuals within their organisation who consider themselves to be disabled. But similarly to ethnicity pay gap reporting, there continue to be calls for mandatory disability pay gap reporting, and there's a consultation ongoing at the moment looking into that again, and a response is actually expected later this month. So it's possible that there will be a new requirement introduced.
All right, thanks, Moira. And Kate, I want to turn to you. Somewhat different, but I think related, is the National Labor Relations Act in the US and what impact that has on employees' ability to share information about equity. So maybe give us a little bit of background on that and how that plays into this.
Sure. So the National Labor Relations Act is a federal law that was enacted in 1935 and which has not really changed significantly since 1947. And this was a law that came about in the aftermath of the Great Depression. And in creating this law, Congress was really motivated by economic concerns. This isn't really a statute about we should give workers these things because workers deserve these things. It was a statute motivated by how do we increase workers' ability to collectively bargain so they can put more money in their pockets and in turn pump that money into the US economy. The National Labor Relations Act guarantees to workers the right to join unions and assist unions. It also guarantees to workers who do not have a union as their representative the ability to act collectively, to engage in what are called protected concerted activities. And one such protected concerted activity would necessarily include one worker talking to another about their wages. So for that reason, in the US, it is unlawful for an employer to have a policy that would prohibit workers from discussing their wages with each other. And it would certainly be unlawful for the employer to enforce such a policy. And the protections of the National Labor Relations Act are pretty broad. Not only are you entitled as a statutory employee to discuss your wages, you're entitled so long as the action is collective to voice your concerns about your wages. So for example, a worker could post on social media, hey, Bob is a really bad boss. Bob doesn't pay a living wage to his employees, and that would fall under the protection of Section 7 of the National Labor Relations Act. One final point on the National Labor Relations Act and wages and getting information about how other employees are paid. The Act contains an obligation that employers and unions bargain in good faith. And part of good faith bargaining means that upon request by the union, the employer is required to furnish to it certain information which is relevant to collective bargaining, but which is also relevant to the union's ability to enforce the collective bargaining agreement. And that information could include information about wages, information about how wages are paid across a breakdown of employees from different races or different sexes. Thank you.
Thanks, Kate. Quickly, Hana, I just want to get your, if there's anything analogous in the UAE related to reporting requirements. I know you've talked some about the changes brought by the new labor law, but is there any analogous initiatives in the UAE?
Well, so recently the equal pay was introduced in the new law, so men and women should be paid equally. However, we don't have any reporting obligation. Everyone was asking, like, how would this be proved unless you speak, with your colleagues and know that they are getting paid more than you. Otherwise, there's no reporting. The only way that we find helpful is sometimes you get inspectors from the Ministry of Human Resources and Labor. They can inspect the records and see, the payment that is done for men and women compared to each others. However, I've never heard of any incident like this or any company that was fined because of this. I know about one case only in the courts where a female learned from her colleagues that her male colleague is getting paid more than her, although they have the same, experience and they do the same job. She went to the court and asked for damages and for the, the difference in the pay. But then the company settled with her outside the court, and that's it. So it's still untested. We're not sure how this will be implemented and how it, employers would be, would employees know that employers are not applying the equal pay. But it's interesting to hear about how is it in the US and in the UK. And maybe this is something, us as employment lawyers, maybe we should escalate such experiences in other jurisdictions to the Ministry of Labor and Human Resources, and we could use such good experience.
All right, thanks, Hana. So we're going to turn to the next topic. Elisha, you're going to talk some about diversity, equity, and inclusion. I think when we were talking earlier on about some of the big shifts in discrimination law, you talked a little bit about also, naturally that ties in with these. I think as soon as you get an acronym that everybody knows, like DE&I, and you're saying it that often, it's become ubiquitous in our field. So maybe you can talk a little bit about what prompted the increased focus. I think you alluded to that earlier, and what it means from what you do and kind of a day-to-day basis, and what you see with that being one of your primary focuses in your practice.
Absolutely, Michael. Glad to dive in here. So as I alluded to previously, and you mentioned, we talked about 2020 and the aftermath, but it's important to talk about what came before. So diversity, equity, and inclusion is not a new topic. It's just an evolving topic. For example, the Black Lives Matters movement, the BLM movement, didn't jump from whole cloth in 2020. Rather, it was a creation in the aftermath of the George Zimmerman trial for the killing of Trayvon Martin back in 2013, right? And so it's just that in 2020, we all put a collective attention, both individually and on a corporate-wide basis, on this topic, and thereafter found an uptick in programming. Many organizations, many great organizations and corporations throughout the world had pre-existing programs. It just hadn't been as much focus. And so, like you said, some of us call it diversity, equity, and inclusion. Others call it inclusion, equity, and diversity. Others yet, and I particularly enjoy this one, call it justice, equity, diversity, and inclusion. And I like it because for those of you who are Star Wars fans, that comes down to Jedi. But no matter what you call it, the concept here is the same, right? Ensuring that we are giving everyone the opportunities that they need so that all boats do rise. But it doesn't necessarily mean giving everyone the equal thing. It means giving everyone what they need to ensure that equity occurs. And employers are going about this in unique ways. Something I always tell my clients is that there is no one-size-fits-all DE&I programming. And by DEI programming, I mean your overarching strategy for DE&I, within which you might have individual DE&I initiatives. Think of them as little bubbles within them. And those bubbles, they look different. The way in which you combine them looks different for different organizations, depending on whether you are a mom and pop shop down the street or a multinational organization. And in my advice and counsel, I speak to folks on both sides of that spectrum and everything in between. But it's important to, just like individuals, companies are unique, and it's important to honor our own ethos as an organization and be true and authentic to it, because otherwise engaging in DE&I programming, which is not authentic, is a surefire way to turn off stakeholders and simply not move that needle forward. So what does that mean for a lot of employers? Here are some of the hot topics in the DE&I world, some of the hot bubbles, tools, initiatives, whatever you might want to call them. And the general gist of which is diversity, equity, and inclusion. I think, in my mind's eye, diversity often is much akin to the recruitment phase of employment life cycles, sucking in a diverse array of individuals into your organization. Equity and inclusion come next. Inclusion is ensuring that once you've sucked in this diverse array into your organization, you are shoving them up the pipeline over the course of their careers so that they can reach the highest rungs of leadership. That is not unlike your retention pipeline. So recruitment and retention, equity falling in between. Equity is the elbow grease of ensuring that we're doing the right things, learning sessions, updating handbooks and policies, developing mentorship programs, successionship planning, all those really boring things, the infrastructure on which we hang inclusion. And so that's usually the three different, very large buckets within which my advice and counsel has been following. The hot topics in the recruitment end of things tend to be something you've likely heard of, inclusive slates. They're sometimes called the Mansfield Rule, sometimes called the Rooney Rule. The general gist of which is ensuring that in every slate of candidates that a company considers for a position, not assuring hiring, mind you, but assuring interviewing a diverse array of individuals. The Rooney Rule, for example, which was the rule adopted by the NFL, the football league in the US. You can see that I am South Asian. I moved here when I was 17. I called it the football league. That's likely not what they actually called it. But the NFL adopted the Rooney Rule, which is ensuring that you have at least one female and one minority candidate on every slate of applicants to be interviewed for head coach positions. Recently come under some attack due to the Brian Flores lawsuit, which claims that the NFL was following the word but not the spirit of the rule. That being said, the other more evolved perhaps aspect of the Rooney Rule is the Mansfield Rule, which was adopted through diversity labs and then thereafter adopted by vast majority of law firms and in-house legal departments assures 30% of every slate of candidates be diverse, and not just in hiring, but also in promotion decisions. So sort of an evolved version of the Rooney Rule. Various employers trying to make those rules their own, implementing policies, retraining their talent acquisition teams, ensuring that hiring managers are screened off from that process, because indeed in the US at least, hiring managers should only be making decisions based on business-related criteria, not protected categories. So really hot stuff in the recruitment side of things. What are we talking about in the retention side of things? Employee resource groups. You heard me talk about ERGs a little earlier. Hot topics over there. Those are supposed to be social networking organizations. allowing individuals of all ilk to come together and foster their development of their careers. Harkening back, I like to think of this as, if you remember all the movies from the 1950s and such, a bunch of professionals get together and go play golf and drink 3 martini lunches. And that kind of social networking helps foster a career development. I'm not saying that all ERGs have 3 martini lunches. In fact, I'm pretty sure they don't, but the concept there is the same. Building those interpersonal relationships that help foster your career moving forward. They can go sideways, though, at least in the US, where they turn into company unions and try to advocate instead of being a social networking organization, and then try to engage in bilateral negotiations with companies, thereby potentially violating the National Labor Relations Act. More and more ERGs have to be good shepherded. So there is our help, the help of counsel that becomes a big part in both the development of a stable ERG and then what I like to call the good shepherding of a stable ERG, because all these programs, any program in the IE&D, DE&I space is not something that you can just create and set on its way. It's something that requires continuous tending, or some of these can go sideways, can become legally non-compliant. One more thing I want to mention before I turn the baton back over to you, Michael. Really important to see where the EEOC and the government agencies are going vis-a-vis DE&I programming. Real attention being placed on artificial intelligence in the US by the EEOC. Why? Because various companies want to scale up their DE&I programming. Individual talent acquisition members taking care of individual hiring decisions. That's a lot of elbow grease. That is high capital investment. It's not always easy for the bigger folks among us to scale up. And so they're saying, yes, what about artificial intelligence? The problem with artificial intelligence is it learns from us. And unfortunately, we humans are flawed creatures. And so it can be taught unconscious bias, and it can replicate homogenous workforces because it is replicating our past hiring and promotion decisions. EEOC putting real attention on that in all the different ways in which the AI can play into the employment life cycles, and indeed various individual jurisdictions, including New York, implementing their own regulations to prohibit the use of AI in employment decisions. So real futuristic stuff over here, really exciting in the employment space in the US and beyond. Back to you, Michael.
All right, thanks, Elisha. So I know there's a few other, and Moira, we're going to have you weigh in on this. I want to make sure that we get to the last topic we want to cover, and then at the end, if we have some time for question and answers, or I'll have people kind of give some final thoughts on things coming down the pipeline. But I want to turn it over to Kate to talk about the new union movement in the US. I think specifically, one of the things we've seen both, I think, not just the union side, but for non-union workers has been a push for higher minimum wage. And that has taken hold, I think, in some states, but the federal has remained unchanged for, I forget how many years now, a while. And there's been a higher rate of resignations, push for more flexible work arrangements during the pandemic. And then a labor shortage that has occurred in the US, which has also prompted companies to have to offer more. But it's also seen, as we talked about in preparing for this, renewed union organization effort in the private sector that's garnered some attention in recent years, so recent months even. So what can you tell us about some of the background? I think we talked a little bit about the NLRA and the background of it, but what has been the impetus or the impetuses for this, the new labor movement? What are some examples of what has happened and sort of the work that you've been doing during this?
So let me start off at the beginning. I talked about the National Labor Relations Act briefly, and that provides the framework for private sector union organizing in the United States. And there are basically two options under this law. The first is the employer will agree to voluntarily recognize the union as the representative of the employees. And the union does this by gathering cards, and cards that are signed by the employees who desire union representation. And then the union just tells the employer, we have a majority of cards, will you voluntarily recognize us? And as you might expect, that the employer actually agrees to do that very rarely. The second option, which is the more common, is the union collects signed cards from at least 30% of the employees in the unit or group it wants to represent, and it files what's called a petition with the National Labor Relations Board. And that sets in process a whole procedure. The easiest thing that can happen, and what happens most of the time, is that the parties stipulate to an election, and an election takes place. Sometimes there's a hearing where both sides would make arguments about, what should the proper unit be, who should be in this unit, et cetera. A lot of employers favor the second choice. They favor going through the board process and not voluntarily recognizing, because it affords them more time to mount a very vigorous anti-union campaign. And there's a whole industry here in the US that has grown up around that, where an employer will pay consultants or may even have its own in-house team to come in and talk to the workers about why unions are bad and why they should not vote to have one come in. And a lot of the times this is accomplished through one-on-one meetings between management and the workers. They're called captive audience meetings. The idea being that the worker is held captive because it's happening on work time and the worker has to attend. And what unions have seen is that while they start off at the beginning of their unionization campaign with a lot of worker support, maybe even total worker support on cards, as the hearing process unfolds and as more time elapses in getting to an election, the employer has more time to implement these tactics, and ultimately employees do not vote for the union when it comes down to it. So the law itself, the National Labor Relations Act, really has not changed since 1947, but what has changed is how different board members and different NLRB general counsel are pushing to interpret the law. So this is a matter of federal administrative law. The National Labor Relations Board has a 5-member board, also called the National Labor Relations Board. And there is a general counsel who is appointed by the president, and the general counsel decides what types of cases to push. And some of the current general counsel's initiatives have to do around making it easier for employees to form unions. For example, there's talk about the National Labor Relations Board returning to the Joy Silk doctrine, which hasn't really been in place for 50 years. It's sort of fallen out of use, but under that doctrine, it would sort of work like voluntary recognition. The union would go to the employer and say, we have a majority, and the employer could only force an election if it had a good faith belief that the union did not really have the majority. As has been discussed previously, there are a lot of things that are feeding into what I'm sure you've all read and heard about the current surge in unionization efforts in the US. Part of it, I think the number one factor is how social justice initiatives have really become front and center in the wake, not only of the COVID-19 pandemic and its really disproportionate effect in the US on communities of color, but on the murder of George Floyd, and how that has really pushed the Black Lives Matter to the forefront. As was previously said, that movement existed beforehand, but I think in late spring, early summer 2020, we saw the convergence of Americans' frustration with what was happening in COVID, a very high death rate in this country, and George Floyd's murder, which was videotaped and which was played out on TV for people to see. I think the pandemic has also played a role in the sense that you have a lot of workers now, for example, at Amazon facilities and Starbucks, which is the coffee chain, at Starbucks shops, who have been present in the workplace during the height of the pandemic, particularly in Amazon, the facility in Staten Island, JFK 8, of 8,000 workers who voted to unionize. COVID health and safety issues undeniably played a massive role in the workers' decision to unionize. I mean, we had the situation, and we still do to an extent, where a lot of Americans have been able to work remotely, have been able to work from home, have spared themselves the brunt of the pandemic. And then we have the frontline workers, many of them people of color who have gone into work every day and have picked the items in the warehouse, have packaged the items, and have delivered the items to people's homes. So I think undeniably the sort of the divide that's created in this country, it's also created a sort of solidarity between the people who have been going into work every day. Factor 3, in my opinion, this is a young worker movement. These are workers who are at the younger end of the millennial generation, also members of Gen Z or the Zoomers. Christian Smalls, who orchestrated the organizing success at JFK 8. He's only, I think, 33 or 34 years old. And I really believe, and this is my personal view, you may disagree, but I believe that this generation has a different view of the importance of acting collectively. I think they realize that maybe what my generation believed, that if you worked hard and you went to college and you followed the right steps, you were going to have a degree of economic security. I think the younger generation has really realized that this is a lie, and the only way they can go forward is collectively. Another factor is I think college education. We have a generation of workers that has not fully recovered from the recession in 2009. You have a lot of college educated workers, some of whom have advanced degrees, working retail jobs, which you didn't see as much of in the past. And I think those college educated workers bring some different things to the workforce. I think they bring a certain amount of entitlement, and I'm not using that in a pejorative sense, but I think they do have a sense that they expect more and they deserve more. I think they have a certain amount of historical perspective that they may have gained from their studies about what unions have done and what unions continue to do for the working and middle class. And finally, I think in a lot of these successful organizing campaigns, the employer's progressive corporate branding has sort of come back to bite it. And you see this with Starbucks, you know, a hyper-capitalist company that has chains all over the US. They hold themselves out as really being truly progressive. They say, well, we support LGBTQ rights. We provide good benefits for our employees, you know, so long as they work the 20 hours. And I think when you hold yourself out that way as an employer, it's only reasonable for your employees to ask, well, where's your progressivism as regards our right to organize? Why do you have a problem with us acting collectively? And of course, when you see the CEOs of some of these companies going up into space on their private space flights, that underlines that. So that's kind of what I think about. Those are the ingredients, both of why there's a resurgent union movement in the US, and two, those are the common elements of why the campaigns that have been successful. Of course, there are a number of recent union campaigns that have not been successful. I'm thinking of the Amazon vote in Bessemer, Alabama, where twice now workers have voted against unionization. Not all of the Starbucks locations have voted to unionize, although the vast majority have. And of course, a month after the massive victory at JFK 8 at the Amazon facility, there workers at another Staten Island Amazon facility voted in favor of not having a union. I don't have a lot of insight into why or why not. I've read what other people have said. I don't have an organizing background. Some people say, well, the second Amazon campaign was too corporate. They brought in Bernie Sanders. They brought in AOC to talk to the workers. That turned off the workers. Some people say that the more established union that was doing the organizing in Bessemer, that union's organizers were out of touch with what the workers in the plant actually wanted to hear and what they needed. Some people have opined that the union playbook just needs to get thrown out and we need to start it over from scratch. My take on this is that this is really a numbers game, and that union momentum is going to build more union momentum, but there are also going to be losses. And that's just part of it. I mean, I think the underlying question, I think, is even if the current NLRB general counsel is successful in pushing her initiatives, even if the meaning of who is an employee under the National Labor Relations Act, who is entitled to do this in the first place, even if that gets broadened to encompass independent contractors, and even if it becomes easier, if there's a more streamlined procedure for employees to select whether they want to have a union, I think at the end of the day, we're stuck with the issue that some people just vote against their self-interests. And here in the US, you know, we've obviously experienced that on a national level, and we've seen how that works. Thank you.
Thanks, Kate. So we have a few minutes before we're going to switch into the breakouts, but the one question we have in the chat from Arthur Nicholson is, has the COVID pandemic resulted in more than temporary changes in the employment laws in the UAE, UK, and France? So Hana, do you want to talk about if there have been any sort of lasting changes from some of the issues that were dealt with? Or I guess.
Yeah, that's a good question. I think the pandemic had an impact on the new amended laws, labor laws. And one of the main things is introducing the remote working, which wasn't the case before, and flexible working hours. And also the new law gave the employer the ability in the event of special urgent circumstances or emergency circumstances such as pandemics to reduce or decrease the employees' salaries or put them, you know, in sabbatical just for some period of time because of the emergency financial distress that the employer is going through. So this is, you know, it's helpful for the employers. I know it might not be favorable to the employees, but then we need to take into consideration the employer's financial situation during, you know, pandemics and special circumstances or emergency circumstances like this. And now we've seen new templates for contracts or labor contracts from the Ministry of Labor, where you can apply and say, I agree with my employer to work remotely or work part-time or work for flexible hours. And this is a new template that's after, or it was implemented after the pandemic. So I would say, yes, there was a big impact from the pandemic.
Thanks, Hana. And Moira, how about in the UK?
So I think in the UK, there probably aren't any new laws, employment laws as yet, but there's potential for new employment laws to be put through. But there's certainly a change in working practices following the pandemic. As Hana said, hybrid working is the new normal, and there is much more emphasis on an increase of rights for flexible working. There's another consultation, I know I keep talking about consultations, but there is a consultation going on at the moment about flexible working in the UK. So we do currently have a regime in place for employees to request flexible working, but there's a consultation looking into whether or not there should be changes made to that to make it more widely available, in a nutshell. And I also just wanted to mention that I can recognise a lot of the points that Kate and Elisha were talking about in terms of the trends in the US. A lot of the same trends are also reflected in the UK in terms of Black Lives Matter and the impact of that, and continuing that conversation, as well as AI in the workplace and trying to navigate the risks and difficulties with that developing area. Thank you.
Okay, in the last couple minutes then before we shift, Elisha, if there's any final thoughts or anything you want to add to that. I know we have talked some about the COVID in the US, but anything you want to add before we shift?
Yeah, I wanted to actually harken back to what Kate was talking about with regards to the union environment, and without making any particular specific examples, I do think there is a trend towards unions understanding that traditional topics in which they fostered unionization in the US, things like wage and hour issues, safety, et cetera, which were the crux of the conversation in decades past, not really resonating with the workforces any longer. Instead, it's the social justice message, as Kate hearkened to, that seems to be catching a younger generation's attention, and that's where the focus seems to be. More recently, I've seen a lot of talk from unions about civil rights audits, i.e. climate assessments that they are asking employers to conduct and then publish for workforces. So a new and emerging trend over there to keep our eyeballs on, and the evolution of what that means, both for obligations on employers as well as relations with workforces.
Thanks, Alicia. So, and thank you to our 4 panelists. We asked all of you to condense days worth of presentations into about 5 minutes each. So I really appreciate it. And hopefully we can keep this discussion going in the breakouts. So in a couple of minutes, or hopefully this will happen automatically because I don't know how to do it. But everybody will go into breakout rooms, about 4 or 5. We can continue some of the discussions from the topics we talked about today. I think it's a really good opportunity. And I know when we did this last year, everyone really enjoyed just kind of hearing what people do, where they're practicing, some of the issues they're facing. Obviously, there's a lot to talk about, a lot we covered just today. So we'll be about 20 minutes doing that. Then we'll come back for some final thoughts. And then we'll go back to whether it's morning, afternoon, or evening where you are. So so that should happen. I don't know if I need to turn that over to Rose or anyone from the AVA here, but okay, I think we are all back. I hope everyone enjoyed that opportunity. I think it's always very interesting, especially to go in blindly, get to meet people from all over the world and hear different perspectives. So I hope you all enjoyed it as much as I did. I just want to say another huge thank you to our panelists. It was a lot of preparation to condense everything that we do all day, every day, to a few minutes. So as I said a few times, I know there's a lot more we could talk about and full days we could do on this, but But I think it's interesting to hear where our different countries, where our different practices are, what kinds of things are coming down the pike, and obviously, every day, and I think it's been this way for a while, there's a lot of overlap and intersection, even if it's not where we actually practice. So, so thank you, everyone. I think in terms of, I'm going to put in the chat here the American Bar Association, where you can join if you're interested in finding out more about it. It's also there, and then my my email address I'll put in there for anyone who's interested, either who's already an ABA member, not an ABA member, whether you're interested in just finding out more about what we do or ways to get involved. We're always looking for people who are interested in speaking or in writing. We have, as I said, many conferences throughout the year, and that present opportunities. And so we're always looking for people to do that. The next big event will be in the fall, and I apologize, I don't have the dates right in front of me, I should, but in second week in November, we'll have our labor and employment law section conference for the ABA. This year, it's going to be in Washington, DC, where my firm is based, actually. It's always really great. We always we have panels with an international focus. We have different tracks in it that I've often coordinated a whistleblower track. We have tracks on discrimination law, benefits, and a lot of practical sessions on litigating types of claims that we do. So a big plug for that. If there's a good entree into the ABA, especially for labor and employment lawyers, I think that's a big one. And then we'll continue our partnership with AIJA. We hope to leadership continues to have regular meetings with them. If anyone has ideas, I know Caroline's open to them. I'm open to them on ways to continue to do panels like this throughout the year. And I'll turn it over to Caroline for final words. But again, thank you to everyone for making the time. I know it's, for some people, it was very convenient and in the middle of their day like me, and for some it wasn't. So thank you all, and I hope you enjoyed it. So Caroline.
Thanks, Mike. First of all, thank you again, Mike, and thank you to all the speakers, because I think the topics were very interested, and the discussions we had during the breakout sessions prove it, because we've been able to discuss a little bit more about the topics that were raised, and that was really fantastic. I've put in the chat the link to the website of AIJA, where you can find the next events. The main one will be the Congress in Singapore, 22nd, 27th of August, and then our annual Labor Law Conference in Amsterdam in October. For the ABA members, will be on the US soil next year, because we'll have our annual conference in New York in June 2023. So I hope that will be a good occasion to meet some of you in real life, if we haven't met before, maybe in Washington in November, Mike. So thank you again. I was really happy to see all of you today, and I hope that we can organize this kind of events very soon again.
All right. Thank you, everybody. I hope you have a good rest of your day, and hope to see you at another event soon.
Thank you, everyone.
Thank you. Bye-bye.